thanks to all of you for coming tonight and for inviting us, Patrick Crooks and Ann Walsh Bradley, Justices of the Wisconsin Supreme Court, to this forum. I, indeed, am Ann Walsh Bradley, born and raised in Richland Center, Wisconsin. If any of you know where Richland Center is, I call it the Mecca of the Midwest. Some agree, some disagree. Live in Wausau and have lived there since I graduated from law school, from this law school, and was first elected to the Wisconsin Supreme Court in 1995. Before that, I was a circuit court judge in Marathon County for 10 years. When I think of opening remarks tonight, I think of three meetings, three gatherings. The first is right before me, the gathering that we're going to engage in tonight, and the discussion we're going to engage in justice, money, and politics. I think of a gathering last week, for it was last week that Justice Crooks and I and the other justices, along with all of the judges in this state that were able to participate, attended our annual judicial conference. It was held this year in Madison. And as is our tradition, the Chief Justice kicks off the event with giving a State of the Judiciary. And this year she started her State of the Judiciary, that gathering last week here in Madison, with these words. Chief Justice Shirley Abrahamson said, "We do not work for special interests, associations, advocacy groups, or political parties of any kind, pro or anti-anything. We work," she said, "instead for the 5.6 million people who call this great state home. They are the all in justice for all." The third meeting that comes to mind, also held here in Madison, was a few years ago. I think of, turn back with me, if you will, to those thrilling days of yesteryear. November 18th, the anniversary today. But this was November 18th of 1846. And what was going on November 18th, 1846? They were having a meeting. It was our first constitutional convention. And then a fellow, an Irishman, Edward Ryan, one of the leaders in our territorial days, went on to become Chief Justice of the Wisconsin Supreme Court. He served in the 1870s. But this was in 1846, November 18th, and what was he debating? He was debating how we in Wisconsin are going to elect our judiciary. He was debating with others at that first constitutional convention in 1846, how can we best safeguard this third branch of government? How can we enhance and maintain a fair, neutral, impartial judiciary? So, you know, some things never change, do they? Here we are 162 years or so later, talking about the same thing. And I expect tonight that there is going to be no shortage of promising and good ideas for reform. We've read about them, we've heard about them. They include such things as public financing, sensible recusal procedures. Some would have reform with regard to disclosure of interest groups, spending in judicial races, alternative methods of judicial selection, standards of judicial conduct that are clear and enforceable. And as in all of these good and promising ideas, sometimes, as we say, the devil is in the details. But having good and promising ideas is not our problem. We've got a lot of them. I think the problem is not a lack of ideas, rather it is a lack of leadership, and it is a lack of political will to bring about the necessary reforms. So some of the discussion tonight, I hope, will focus on leadership and encourage and enhance the political will to bring about reforms that will maintain Wisconsin's neutral, fair, impartial, and nonpartisan judiciary. So, N. Patrick Crooks, it's your turn.
Okay. You're probably not going to believe this, but Ann and I really didn't rehearse this together. But we both were at sort of the same starting point. And I was going to tell you that when I ran for the court and was elected in 1996, that I made the announcement that I was running for the court from the porch of a home up in Green Bay, my hometown. And that porch was on a house called Hazelwood. And interestingly enough, Hazelwood was the home of a fellow named Morgan L. Martin. He just happened to be the fellow who presided over the constitutional conventions in Wisconsin. Now, Ann mentioned the convention of 1846. If you go back and you read the discussion and the debate in 1846, it was really interesting. They were debating three options as to how they should select judges. One was the judicial election by the people. The second was judicial appointment by the governor. And the third option was judicial appointment by a joint ballot of the legislature. Now, I'm not so sure that wouldn't have resulted in some real deadlocks, but in any case, that was the third option that they were looking at. And as I think you all know, judicial election won. They also debated in 1846 the length of terms of judges. But as many of you in this room know, what happened was the 1846 Constitution was rejected. It was rejected by the people for several reasons. One reason had to do with exemptions from judgment. Another had to do with property rights of married women. Another had to do with the right of African Americans to vote. So what did the Constitutional Convention in 1848 do? They changed things. They dropped all of the constitutional provisions that were controversial. And without question, there was a resounding adoption of the Wisconsin Constitution. Shortly thereafter, by the way, they addressed in the legislature many of the same issues and adopted legislation that pretty well covered what had been in the original Constitution. But the point is that the people of Wisconsin in Constitutional Convention, both in 1846 and 1848, said we want elections of judges by the people. Now, in 1848, the debate was over 5 years or 10 years. The debate was pretty well over by 1848 that they were going to have selection of judges by election. But then it was, should we have 5-year terms or 10-year terms? Well, interestingly enough, they adopted one only to change it shortly thereafter to the other. Now what we have is, I think many of you know, is 6-year terms for judges on the circuit court and judges on the Court of Appeals, and a 10-year term for a justice on the Wisconsin Supreme Court. I was fortunate enough to have my law clerk in her spare time, and I have to tell you there isn't much spare time, but in her spare time she dug out some law review articles in regard to what I know you're going to hear from Mr. Milfred about, and that's merit selection, or I call it the so-called merit selection. And what I think is important is to look at what's been written recently after research in regard to merit selection. I'm going to start, there's an Albany Law Review that came out in 2004, and the title was Examining the Decline in Support for Merit Selection in the States, written by a fellow named Seth Anderson. And I just want to read you a couple of the sections, because I think it sort of says that things are changing in regard to this idea of merit selection. First, and I'm quoting from the article, proponents of judicial merit selection have suffered several setbacks of late, most recently in Florida in 2000, when all counties and judicial districts in the state voted overwhelmingly to reject a proposed local option constitutional amendment to move from nonpartisan elections to merit selection and retention for circuit and county court judgeships. Ohio voters rejected a proposed merit selection amendment in 1987, and long-standing efforts in Illinois, Louisiana, Michigan, and Texas, among other states, have failed to gain legislative support. The focus of judicial selection reform has shifted decisively to statutory, regulatory, and voluntary measures such as public financing of judicial campaigns, contribution limits, and enhanced voter education efforts that are designed to improve but not eliminate contested judicial elections. Quite obviously, from the articles I'm going to quote, I favor continuing with judicial elections. Now here's another quote, and this is very interesting, I think. A national public opinion survey conducted by Harris Interactive for the American Bar Association in 2002 asked respondents to choose whether elected or appointed judges are more likely to be fair and impartial. The results of this survey illustrated that 75% of respondents chose elected judges, while only 18% chose appointed judges. Likewise, in a national survey of voters conducted by the Justice at Stake campaign in 2001, 76% of respondents favored judicial elections to only 20% for judicial appointment. So what that tells me is that the surge really is not to go with merit selection. The surge, what's going on in this country, is not to do away with judicial elections, but to look at reforms that will help make judicial elections more fair and achieve what really should be achieved in a judicial election. And that's the selection of the best person running. Now, I want to do a little more quoting. This is another Albany Law Review article. This one is from 2005, and it has to do with judicial selection reform. I'm just going to quote a little bit of this. This has to do with the New York Court of Appeals and the approach that they take there. The New York Court of Appeals is their highest court, their court of last resort, comparable to our Wisconsin Supreme Court. And they have a judicial nomination commission. The commission in turn selects 3 to 7 names to send to the governor. Among other things, this has given rise to the perception of the governor's heavy influence over the judicial nomination process and the belief that the governor's favorite will be included in the 7 and then chosen by the governor. This has contributed to skepticism or cynicism among potential applicants, and in addition resulted in a relative scarcity of applicants. So the merit selection process doesn't seem to be going very well in the state of New York. Now, here's something from the Dickinson Law Review, and this is 2002. Has to do with merit selection, a review of social science literature. And again, I'm just going to quote a couple of things that I found very interesting. A substantial body of research exists on the extent to which politics plays a role in the selection of members of nominating commissions and the decisions they make. The Henshin study discovered extensive political activity among nominating commissioners prior to their selection. Watson and Downing, two researchers, also presented evidence of political influence in the selection of nominees by the commissions. And then going down and talking about the famous Missouri plan. This is the one that's always been held out as the ideal in terms of merit selection. Missouri nonpartisan court plan indicated that the plan had not eliminated politics, but merely had substituted, this is a study of that plan, but merely had substituted bar politics and gubernatorial politics for the traditional politics of party leaders and machines. So politics didn't exactly fade away in the state of Missouri. It's also interesting to note, and I'll give you one more quote, actually two more. This is still from the Dickinson Law Review. The most recent study of selection systems and judicial diversity finds no evidence that women and minorities are more likely to become state appellate judges under merit systems than they are under non-merit systems. So those that would argue that diversity will be furthered by merit selection, the studies don't seem to bear that out. And then here's two more researchers, Glick and Emmert. They found few differences in terms of qualifications between judges identified through merit plans and judges chosen through other systems. Merit-selected judges did not have more legal or judicial experience than judges chosen by other means, and they were just as likely as other judges to have had partisan political careers. So I think that's in some way a bit of an answer to the argument that the judiciary is going to be greatly improved by the merit selection process, that we the people shouldn't be involved in selecting the judges, but rather it should be allowed to work through a process of a selection commission. If not merit selection, what's the answer? Well, Ann Bradley touched on this a little bit, and I want to touch on it for just a minute as well. 7 members of our court, and we don't always agree unanimously on anything, but we did in this instance. 7 of us sent a letter to the governor and to the legislators here in the state of Wisconsin, and we said we're not endorsing any particular public financing plan, but we think that there's a need for greater public financing of Supreme Court races. Now, I know it was mentioned earlier, we've got some public financing in Wisconsin. Well, let me tell you what that amounts to. When I was elected to the court in 1996, Ralph Fine and myself were the finalists, and we each got $17,000. Try running a statewide campaign on $17,000. It probably bought us a couple of ads in the Madison market and maybe 1 or 2 in Green Bay, but that's about it. That's not realistic public financing, and part of the problem is we don't have realistic public financing. What else do we need to do? Now, these are all my ideas, and I'm stealing them from lots of other people who have said the same thing, but I'm trying to summarize them. We need caps on the candidate contributions. That sort of goes hand in hand with the idea of public financing. We need disclosure of contributors from outside groups. Now, I recognize that these are delicate legal issues involving First Amendment issues, and yet I think it's appropriate that we start looking at the fact that there can be some disclosure required of contributors to the outside groups. We clearly need education of the voters as to the role of the Supreme Court. 19% was the turnout in the April election when Justice Gableman won out over Justice Butler. And we need to do some other things. We need to do a get out the vote drive. Frankly, 19% is something we should all be ashamed of. And lastly, I'll just throw this out. Maybe we should think about a fall election instead of a spring election. Maybe we should tie these races to those races where there's a larger turnout of voters. I think I want to quit at that point. There are several U.S. Supreme Court cases that I might be able to mention during the course of the time that we answer questions. But I want to emphasize to you what sounds like a rather straightforward approach. Don't throw out the baby with the washwater. Don't throw out the baby with the bathwater. The baby is the right to elect, and we don't want to give that up. It's important that we have the right to elect our judges. Reform, yes. Get rid of elections, no.
Well, I don't come to this with a background of legal expertise, okay? I'm a journalist, but I do think that attorneys, and I'm assuming that the room is filled with attorneys, I do think attorneys and journalists have a common experience that they share, and that's that most people don't like us. People don't like journalists because of the things, they don't like a lot of the things that we write. People don't like attorneys because they don't like, you know, the axe murderer that you represent or the hot coffee at McDonald's lawsuit, whatnot. But, and as a result of that, in terms of public opinion, I mean, I'm right there with you, okay? Journalists and attorneys are pretty, they're near the bottom rung, right? But I would hope that you would understand that the vital importance of journalism the same way I understand the vital importance of legal representation. And when the public does need us, boy, do they like us. I mean, when we're on their side, you know, we can change their lives. But so if we're down here in the bottom of the barrel, who's way up at the top? It's the judges. I mean, the judges have always been the pillars of the community. They're the people you go to when you know, any life-changing decision is being made. Life and death, multi-million-dollar lawsuits, crime and punishment, the rights of very unpopular people and groups, right? Individual freedom. And we've always had them up on a pedestal, and I'm afraid that here in Wisconsin, they are falling fast off that pedestal. And I think the key reason for that is that we are turning our esteemed judges into politicians, and we're turning the Supreme Court into a second legislature, where if you don't get what you want in the first legislature, then you go and you go to the second one, maybe throw a few more $1 million into advertising, see if you can win over there. So, and I probably don't have to tell you where, in terms of public opinion, politicians are, or the legislature. Believe it or not, they are even lower than attorneys, and, I'm not making this up, lower than journalists. Can you imagine? And that's why I and my newspaper launched in January a campaign for merit selection. Now, we've heard that apparently merit selection is over with, nobody likes it, it's being beaten up all over the country. In reality, more states do merit selection than any other system. And the idea that appointing judges is somehow foreign, well, it is foreign because the whole rest of the world does it. Our federal government does it. And you know what? We do it. I mean, that's the biggest thing that people don't seem to get. I mean, if I often have people come up and say, oh, Scott, you want that merit selection. You just want, you know, then the governor just gets whoever he wants. And he just gets his cronies in there, and the public has no say. And I said, no, what you just described is the current system. That's what happens right now. The last 50 Supreme Court justices in this state, of the last 50, 33 were appointed when they first got on the court. Guess what kind of limitations there were on who the governor could pick? There were no limitations. The governor can put whoever he wants on the court. And this happens over and over again. Now, sure, they have to face election within a year or two or three. I don't know the rules on that. But by the time they face re-election, they're the incumbent. And we all know how much easier it is to win elections when you're the incumbent. And we just had a really good example of that. A lot of people say, oh, Scott, you just don't like the way these last couple elections went, and that's why you're trying to change things. No, my newspaper endorsed Dianne Sykes over Louis Butler back in 2000. Louis Butler got creamed in that election. Dianne Sykes, she was the incumbent. Why was she the incumbent? Because she had been appointed by a governor. Louis Butler gets creamed. I mean, he got creamed. I don't know if you remember. I want to say it was 2-1. I don't know exactly if it was that. It wasn't that significant? Okay. He did get beat pretty bad, right? Well, I think, all right, we'll look on factcheck.org tomorrow and see if I'm right on that one. But, so what happens? Dianne Sykes gets a better job. She leaves. The governor appoints Louis Butler. Here the public didn't want Louis Butler. The governor put him on there anyway. And then he runs for re-election, and he almost wins. And he was the incumbent. Now, I can't remember the exact numbers, but virtually every incumbent, other than 1 or 2 or maybe 3 over the last 50 Supreme Court justices, has won. So that's our system. So we are appointing our judges already. And we're letting the governor have whoever he wants. That's not the system I want. I'm arguing for merit selection, and you probably all know what it is. I'll try to be short, but Shirley Abrahamson gave her speech last week. She cited extensively Sandra Day O'Connor. Well, the biggest proponent right now of merit selection, what I'm pushing for, is Sandra Day O'Connor. Why? Because it works so well in Arizona. She just spoke at the Milwaukee Law School earlier this year about it. And she's been speaking at colleges all over the country about it. You get a panel, and my preference would be that there be more non-lawyers than lawyers. I can imagine there's some disagreement in this room on that account. But you can do it lots of different ways, and you can stagger the terms, and people say, well, that's just going to be, this political body. Then they're just going to, it's going to be more political than ever. And my Exhibit A on that, I'm not an attorney, but I've watched a little bit of TV. My Exhibit A is the Government Accountability Board. We just created a really good panel. I mean, I know there's some people have some qualms with them, but the Government Accountability Board, shout out to Kevin Kennedy there, I think has been doing really well. And I think people respect their decisions, and we've got these retired judges. They're making the calls. They're more aggressive. And so we can create a neutral panel that the governor doesn't control, that the Republicans or the Democrats or the Libertarians or whoever don't control, and they can put some names forward. And rather than deciding who's going to be on the Supreme Court based on how good of a campaigner you are or how much money you can raise or how many millions of dollars special interest groups can throw at the race, either on your behalf or to tar you, rather than that being how we get to Supreme Court justices when there actually is an election that's contested, I say, why don't we have that panel that we've created here, and they could judge them on competence, experience, reputation. They could look at the history of how often they're overturned. They could look at their demeanor, and we'd get a very, very esteemed court that I think the public would have incredible trust in. I mean, I'm not accusing either of you of, well, so-and-so gave me this money, so I'm gonna go their way. I really am not accusing you of that at all. I think you're both doing a great job. Yeah. But I think...
Count my blessings.
But the public doesn't agree with me. I mean, there's opinion polls that show that a vast majority believes that the money that judges get influences their decisions. That's the problem. And, you know, okay, I'm just this, you know, guy who put on a nice suit from Drabby Vilas Hall. What do I know, right? Well, it wasn't that long ago that, actually it was a while ago, 1973, I have it right here. The governor asked some esteemed people, Governor Lucey in 1973, he formed the Citizen Study Committee on Judicial Organization. And there were some pretty big names on here. One of them was Shirley Abrahamson. Another one was Russ Feingold's dad, Leon. Another one was Herb Cole. There's a whole list of esteemed legal people here. Believe it or not, they were worried about the campaigns back in the 70s. Can you imagine? I mean, I would think that that was pretty softball back then. But they were worried, and so they went to work and they studied it, and what did they come up with? Merit selection. Got it right here. That's what they thought was the best way to go, and it would it would make our judges be judges and not politicians. Now, Justice Bradley brought up Mr. Ryan from the Constitutional Convention. I wasn't going to read this, but as long as we're talking about Edward Ryan back in 1846, I can't say it any better than this. This is why we need merit selection. This is during the Constitution of 1846. I don't know if I can do it justice. Sir, our system requires the election of the legislature because the legislature is a mere agency to record the popular will. Sir, our system requires the election of the political executive because it is a mere agency to enact the political will. And men would have it, by their argument, that the judiciary, too, should be a mere echo of the popular judgment. This, sir, is the question to which they lead me. Is the judiciary, like the legislative and executive, representative? Must its judgments represent the will of the people? Varnish it as you will. That is the plain and simple question. No, sir. No, sir. God forever forbid it. Sir, the law should be the just will of the people, but the judiciary are not to make laws. They are to administer them in judgment. The law should be the just will of the people, but it should be administered according to no will, but according to truth and justice. The office of the judiciary is interpretation, and interpretation cannot be a representative function. The principle of representative democracy does not apply to the judiciary. I did not do it justice, but I tried. So that's what I'm going for. And we have Supreme Court justices come in often to seek our endorsements. And, the last couple that we didn't endorse the last time because we wanted to make a point and get some publicity, and it worked for our merit selection campaign. But in the past, when they've come in, we're used to asking questions and getting answers, and the judges really can't answer anything. I mean, because if they answer something, then it might harm their ability to judge in the future. So we're giving voters basically nothing to go on other than really nasty advertisements. And I think that merit selection is a better way. If I might just quick just go through a few things that I've been hearing a lot from people that why they don't like what I'm doing. It can't happen. That's what I hear more often than not. Here's what I think's going on. I mean, can you imagine if you're elected by the public, how hard would it be for you to stick your head out and say, I don't think any of you people should elect me anymore? I mean, that's not really a winning campaign strategy, is it? So is it so surprising that it's hard to get people to stick their heads out on this and push it? Now, actually, there's Tim Kiefer over there. He tried running, and he didn't win. But there are other people who are in the legislature, some of them who you know, who are going to be pushing this next session. I hope we can get a little momentum going. We've heard that, well, our state history is that we do this. But the state history also is that there was no question back then that was so controversial and created such debate as to whether we should elect or not. And, you know, people back in the 1800s, things changed. I mean, they never saw the Linda Clifford ad with the devilish red light above her head and the werewolf howl. And that wasn't WMC or the Sierra Club or We Act doing that ad. It's a current Supreme Court justice who did that ad. And that's going to make us think that they're upstanding, great people here to take care of our disputes. Now there's a poll. Justice Crooks cited a poll, and I don't know the specifics of that poll, but every poll I've seen, they never ask about merit selection. They just say, you know, do you want to elect the judge, or do you want the governor to appoint them? Well, there was a poll here in Wisconsin, and 78% said they wanted to elect. 6% said they want the governor to appoint. Well, the governor is appointing. The governor's appointing more often than not in terms of when people originally get on the court. So, you know, the current system is obviously not what the public wants, and the polls aren't asking about merit selection. Minnesota is so scared of our system that they're moving towards considering merit selection. And they've got campaign finance reform. That's not going to work, apparently. Let's see, it can't happen. The other thing is, I think the more nasty elections we get, the more and more likely it is to happen. I don't know if it can happen or not. But our newspaper thought, you know what, until somebody really cracks that veneer and gets the discussion going, it's never going to happen. And I think we have successfully gotten, the discussion going. Public financing, I mean, God bless you for public financing. We've endorsed that in the past. I think it's a good idea. I wrote a column, again, going back to Minnesota, I wrote a column 3 years ago saying, my God, Minnesota has is the shining star. They've got this wonderful campaign finance reform thing, and the speaker up there told me, yeah, we don't have the outside groups quite like you do. Well, anyway, now Minnesota, even with that, they're going to merit selection, I hope. The other problem with public financing is that the governor will continue to appoint whoever he wants. I got to wrap up. He'll appoint whoever he wants. Even in public financing, with the majority controlling, with majority influence on the court, I worry about minority interest being protected by the court. If they're sticking up for the majority, how do they stick up for these unpopular groups that nobody likes? And maybe it'll stop this special interest from many, but I'm just losing faith that we're going to be able to stop that money. It's the old cliche of every time you squish the balloon, it pops out somewhere else. So there you go.
Our court system is built on a bedrock principle that judges are not supposed to belong to anyone. They're supposed to be accountable only to the law and the Constitution. And that bedrock principle is cracking. And it is at great risk because of what has gone haywire in our system, especially in the last 2 elections. I think it's important to remember, even as we sort of are in shock about what has happened in 2007 and 2008, it's important to remember that Wisconsin has been electing its Supreme Court justices for over 150 years. This state held its first Supreme Court election back in 1852. And for more than a century and a half, those elections produced a court that was capable of earning the trust and confidence of the people of Wisconsin. And it was not until these last 2 elections that that confidence was shaken, and shaken seriously. And I think it's important to come to terms with the fact that there is now a crisis of confidence with respect to our judiciary. A Republican polling firm, American Viewpoint, did polling here in Wisconsin in January of this year. And one of the findings in that poll jumped off the page at me. It also scared the daylights out of me. That firm found that only 5% of Wisconsin residents believe that campaign contributions to judges have no influence on their decisions. 5% of the public believes that those campaign contributions can be overlooked. The vast majority of people have come to the conclusion that those campaign contributions do influence decisions. And that is a disaster for our judiciary. When the public begins to believe that it's the special interest influence and the campaign donations that are on the minds of our judges when they make rulings on cases before them. And then another polling firm, an independent research firm called Belden, Roussinell and Stewart, did polling here in Wisconsin in late April and early May. And again, one of the things that jumped off the page at me when I looked at those poll results was that half of the people say that they believe that decisions are based on politics and special interest pressure, while about half believe that rulings are based on facts and the law. And so, depending on how you ask the question, you get somewhat different answers, but there is still an alarmingly large percentage who are believing that it's not just the law and the Constitution that's on the minds of our judges. And that's something that I think we have to do something about. We cannot permit our court system to continue down this path because the public's faith and trust in the integrity of our system and the impartiality of our judges is at great risk. And they're at great risk because of the last two Supreme Court elections. Those elections broke the mold. In the 2007 race, there was nearly $6 million spent. That was 4 times more than we had ever seen spent in a Supreme Court race before. Not 4% more or 40% more, 4 times more than we had ever seen before in a state Supreme Court race. And then in the 2008 race, it was even more expensive. The 2007 record was broken again. Now, in those last 2 races, about $12 million was spent between those 2 races. At least, and this is just what we can realistically account for, and I'm sure that some of this slid below the radar and we can't detect it all, but at least $8 million of the $12 million was not spent by the candidates, but rather by 5 lobbying groups and special interest front organizations. 5 groups did spend $2 out of every $3 in the last 2 Supreme Court races, and in the 2008 race, 4 groups, just 4, Wisconsin Manufacturers and Commerce, Club for Growth, Coalition for America's Families, and Greater Wisconsin Committee, did 90% of the television advertising. So these groups have effectively pushed the candidates over to the sidelines, hijacked the campaigns, and they're doing all the talking. To the extent that voters are hearing about these Supreme Court races, they're hearing about it from the special interest groups. 90% of the TV ads were aired by just those 4 groups. The other thing that's happened in these last 2 races is a marked increase in partisanship. I used to look at the fundraising lists of Supreme Court candidates, and you could cross off the office and you could cross off the name of the candidate, and it was easy to tell which fundraising list belonged to a candidate for Supreme Court. Today, if you look at those fundraising lists, they're very difficult to distinguish from any race for partisan office. If you, again, cross off the name of the office and cross off the name of the candidate, it could be a candidate for governor, it could be a candidate for any partisan office in this state. The donor lists are indistinguishable. Now, they used to be that candidates for Supreme Court used to primarily depend on the legal community for campaign contributions. Now you see all of the same kinds of interests that are seeking to influence the process of lawmaking. They're now seeking to influence how laws are interpreted and enforced. So there is a marked increase in partisanship, and of course in these last 2 races, if you look at the people who ran the campaigns, they're party operatives. So the telltale signs of overt partisanship are unmistakable. We have races now, these last 2 races for Supreme Court, that put at great risk, at great peril, the notion that we have a nonpartisan Supreme Court. And we are at risk of being in a situation where we will have nonpartisan Supreme Court races in name only. That, I think, is a real danger sign and something that should alarm us all. And then, of course, and I hardly have to say this, these last 2 races were unrelentingly trashy. The advertising was so negative and nasty that the messages were often highly misleading, in many cases downright untruthful. And in all cases, virtually all cases, they were unrelentingly trashy. And that, of course, will only drive those poll numbers in a direction that should further alarm us, where people will increasingly call into question the integrity and the impartiality of those who sit on the Supreme Court. That's a disaster for our judiciary. So I would be the first to agree with Scott that Supreme Court elections have been poisoned. My question, though, is that when you have poisoned elections, should we concentrate on getting rid of the poison, or should we concentrate on getting rid of the elections? And I think we should concentrate on getting rid of the poison. I believe that we should elect judges. I believe a judge should be more than an attorney who knows a governor, and I believe a judge should be more than someone who is the favorite of some jury of peers or some panel of so-called experts. I think that the people ought to be trusted to make these decisions, but what we are now seeing in Wisconsin are not Supreme Court elections. We're seeing court auctions. And I would be the first to say that we have to do something about those auctions, and we have to restore court elections. And so I think 2 things have to happen. At least 2 things. And I think there are other ideas, and I particularly find the notion that maybe we should think about holding these elections in the fall particularly intriguing. Do it when people are most likely to turn out. And so that's a very intriguing idea as well. But aside from other good ideas that I'm sure I'll be able to grab a hold of and endorse, I think at least 2 things ought to happen. First of all, we ought to have publicly financed state Supreme Court elections. And we ought to have real public financing of state Supreme Court elections. The old system is dead broken. It's flat busted. It doesn't work. It worked once. It served our state pretty well for about 10 years, but it is flat busted now. We have to have reform that enables candidates to be free of the money chase and be free of the need to amass those campaign contribution lists that look so very much like those for candidates for partisan offices. And there's a bill out there, the Impartial Justice Bill, that would do just that. And the votes are there. The majority of the members of the new Assembly and new Senate are on record in favor of it. They've either already voted for it once or they have publicly pledged to support it in candidate questionnaires. So the votes are there to pass impartial justice. It should be the very first thing that the new legislature does. But I would be the first one to say that if we only passed the Impartial Justice Bill, I think the court would remain at great risk. Because the problem is that the candidates, yes, would be freed from the money chase, and they would have a source of funding to run their campaigns that would free them from the kinds of influences that are beginning to pollute the court, but they could easily have their races hijacked by those interest groups anyway. So I think the other thing is we've got to make sure that those groups are operating under the same rules as the candidates. We need disclosure rules like those that just passed the Government Accountability Board, and the legislature should approve those, and those should be put in place. Because right now, candidates for Supreme Court are limited in what they can take from individuals. They're limited in what they can take from political action committees. They can't take a penny from a corporate treasury or a labor union's general treasury or a nonprofit group's treasury, and they have to disclose everything. And these groups can take money from anyone, from anywhere, in any amount, and they don't have to disclose a thing. No wonder they spend 2 out of every $3 in the races. No wonder they did 90% of the TV advertising, because they play by a privileged set of rules. And that's dead wrong. Those groups ought to have to disclose where that money's coming from, and they ought to have to follow the laws limiting campaign contributions that have been on the books for many years. They're exploiting a loophole to get around those laws. They ought to play by the same rules as candidates. You do those two things, and you do them in tandem, and we can get back to the point where we were for over a century and a half, where we can have elections for Supreme Court that produce a court that will earn the faith and trust and confidence of the people of Wisconsin. We don't have to leave these people in such a vulnerable position because of the sour direction that these elections are headed today.
I'd like to hear from any of you about the role of citizen in your particular proposal for judicial selection reform.
Certainly, when you talk about elections and preserving the right of the people to elect judges, the citizen obviously is emphasized in that process. But I think there are more things that need to be done. A lot of people do not understand what the Supreme Court does. When you're talking about the ads before, all you have to do is watch those ads and realize what a misconception is being created in terms of what our court does. We're the court of last resort in the state of Wisconsin. We're an appellate court. We don't sentence defendants in criminal cases, just as an example. So education of the citizens, education of the voters, I think is very important. I think there's another thing to this, and that's getting out the vote. When you have 19% of the eligible voters in the state of Wisconsin electing a justice on the Wisconsin Supreme Court, I think that's just atrocious. And so that's another place, certainly, where the citizen plays a major role, in addition to the citizen being involved in doing the actual voting. It's that any of the citizens should be encouraging other people to get out and vote, and certainly should be involved in educating people about the role of the Supreme Court, the real role of the Supreme Court.
I'm worried that if we have our state Supreme Court constantly influenced every election by the majority of people, then the majority now controls the legislature, they control the executive, and now they influence the judicial branch. And I think the judicial branch is supposed to be different. The judicial branch is supposed to stick up for the little guy, stick up for the unpopular guy, stick up for the guy that a lot of us don't like. And that's the citizen that I'm most worried about in this scenario.
The Supreme Court of the state of Wisconsin has had a reputation nationally for our outreach programs, for going around the state, whether it be speaking with students, whether it is one of our innovative programs of taking our courts to different counties around the state and having the Supreme Court heard, arguments heard in those counties. We have countless outreach programs and travel around the state talking to people about the role of the courts and the rule of law. And I am dismayed when I think of, I recently, 2 weeks ago, turned in my car with 190-some thousand miles on to show how much I travel around the state. I am dismayed to think that all of that work and all of that effort about educating about the role of court and the importance of the rule of law can be snapped out like that in some 30-second ad.
One of the real downsides of doing away with contested elections is you do away with an important opportunity for members of the court and court hopefuls to get out and talk about the purpose of the Supreme Court and educate the public. and instead they would be sequestered in their offices and doing what judges do, but they wouldn't be out there campaigning, talking about the role of the court. But my concern about what's happened in these last 2 elections is that it's now possible for a group to come in with millions of dollars and render what you've done, putting 190,000 miles on your car, functionally meaningless, because they can undo all that good work by being in the living rooms of millions of people every morning, noon, and night with these 30-second ads saying that a good judge should lock them up and throw away the key, that it's all about fighting crime, when in fact, this is an appeals court. You know, the majority of your cases aren't criminal cases, and you don't try people for crimes, and you don't sentence convicted criminals. That's not the Supreme Court's role, and yet you look at those ads, you're absolutely right. Over and over and over again, the ads created an impression that the Supreme Court works on things that, in fact, is a misrepresentation of the court's work. And so what those retired judges on the Government Accountability Board did is incredibly important. What they said is make those groups play by the same rules as the candidates. Make sure that they disclose. Make sure that they obey campaign contribution limits. That would make candidates matter. My fear is that if either of you run for re-election in the future and you have to run in this current environment with the broken system and the auctions that we now have, that these groups can come in and essentially push you to the sidelines and you won't matter. That's something that we've got to do, is make sure candidates matter.